display that for me? Okay, this is my client, correct?
Correct.
And again, this is him while he's trying to be an aspiring artist, correct? This time period?
I guess.
Okay. And first of all, let me just clarify one thing. In the background, we see a gas station. That is the gas station on Cleveland Avenue, correct?
I believe that's 221 Cleveland.
Okay. That's not McDaniel Street.
No.
Okay. Now, Mr. Stillwell, in this post, also makes reference to Donovan Thomas, doesn't he?
He does.
Okay. He makes reference in the hashtag Peanut Stone Grave.
Correct.
Okay. Publicly, he is tethering himself to that incident.
Correct.
Okay. And in the message he writes, in the caption, it says, "I fell off 100 times, 100 times I bounced back." Okay.
Correct.
Let's talk about some things that happened prior to this post about falling down 100 times. Mr. Stillwell, prior to this post, had someone drive by the green store and shoot at his head, did he not?
Correct.
Okay. Mr. Stillwell, prior to this post, was driving in a car with a young lady named Tiara Jones and another lady named Ms. Duncan, and a car sped up behind that car and started shooting at them, correct?
Correct.
And killed Tiara Jones and put Mr. Stillwell in the hospital.
Correct.
Mr. Stillwell, after he spoke to the investigators about the Tiara Jones case, was attacked on social media for talking to the police.
Correct.
All those things happened before he made this post about falling off 100 times and bouncing back.
A lot of things happen, yes.
Okay. Does this post ever say, "I killed Donovan Thomas"?
No, but he's attaching himself to the incident.
You're absolutely right. He's attaching himself to the fact that the police arrested him and people have been attacking him ever since. Isn't that true? I've been knocked down, I fell off 100 times, and 100 times I bounced back.
Objection, speculation. Sustained.
Okay, I'd like to talk to you about some of the work you did in collecting the posts from social media. And again, I don't mean to harp on this. Maybe I'm not asking correctly. I understand that you have given how many total social media posts did you pull within a folder?
I don't know. They were all compiled into a folder of relevant posts.
Okay, you say relevant posts.
Correct.
So who determined if they were relevant?
If they had anything to do with the hyper-violent back and forth, I felt that they were relevant to the investigation.
Okay, again, I'm going to ask, who determined if they were relevant? Who?
It's just that if I felt like they were
So
anything,
you
I would,
determined.
from
you
my as being the person that's listening and monitoring the wiretap and knowing the ins and outs of what's going on, I was able to determine what was relevant.
You determined what was relevant.
Correct.
Okay. And I understand that we have a thing of posts. What I want to know, when you're on Instagram, do you have notifications set for when people post? Are you scrolling Instagram? Are you looking at certain people's pages and not other people's pages? How are you doing it?
We were monitoring both sides of the conflict, and it's not just me. There are several people that would monitor. We'd all look together
Talking
collectively.
about the social media posts.
Correct. We were monitoring both sides. Part of my job is to mitigate violence. So as a conflict is occurring, we're monitoring both sides of the conflict. So when we see, it's a constant job of monitoring, to where if I see YFN down on Cleveland Avenue, which a bunch of assault rifles, probably not great. So we need to monitor constantly to say, okay, we need to get marked units down to Cleveland to mitigate that. So we're constantly, I have a unit that I work with. Everybody was involved in the wiretap, the investigation. So everybody was tuned into what was going on.
Who's in that unit?
I mean, the gang unit, there's a bunch of people. I couldn't tell you give you a roster at that time. It's changed, but.
Okay, well, if we had reports, could we know who was on that unit? Since
They
it's
wouldn't.
changed.
I don't know anybody in our gang unit that would give you a report of every social media post they screenshot.
Okay, well, I didn't ask if anyone in the gang unit would. I asked if you did. Did you write a report about exactly which users you were following to pick up specific posts?
Mr. Shart, you've asked me that before, and I've told you I've compiled every user you see in the folder is who I was monitoring.
Okay, and what about is there no one else that you were monitoring that's not in the folder?
That folder pretty much covers a whole lot of people.
Okay, and we just take it from you. No reports.
Whether you have all the posts, that I captured. They're in a folder, gathered, collectively organized in a folder for you. So I don't know what, do you want a list of screen names that were captured?
Just want documentation of the work you did.
It's documented in a folder that was served in discovery.
Some of those posts that you deemed relevant are actually lyrics to songs, correct?
I'd have to see what you're referring to.
Could you, Ms. Knight, could you display 471 VV? 471? Okay, this is Mr. Nichols, Comarvius Nichols, right?
Correct.
Okay, and 471 VV is exactly how the state has put this into evidence.
Correct.
All right, and we're going to get back to exactly what this is in a little bit.
Correct.
But those words, what you saying, I run with cold-blooded killers, okay? When are you saying that you collected this?
Probably 2 days or a day or two after the murder of Mr. Drinks.
Okay, and those words, those were written by Mr. Nichols?
No, it's a song by NBA Youngboy that he chose those words to put on the post 2 days after Mr. Drinks was killed.
He chose those words?
So what this is it's an Instagram story, and you can select a song and which portion of that song. You can select anywhere from 10 seconds to 30 seconds, and you select that, and you can overlay it onto your story. That's what was done here.
Those words?
Mr. Nichols made the social media post, and in the post, he picked this song to accompany his post.
All right, you know what? We're not going to get back to this. Let's deal with this right now. Mr. Kokomo, if you would, what is it, 60? Yes, 60. Okay, Your Honor, may Mr. Kokomo approach
Yes.
This is what Mr. Atkins. Mr. Atkins told us. Okay. All right. You need to show it to investigator Valeria. Okay. You good? Start from the beginning. Go.
We're gonna hear the audio?
We can.
I mean,
Do you?
yeah, so that is a screen, oh, can I explain?
Yeah.
Okay, Mr. Kokomo, I think the witnesses had sufficient time to view it, so thank you, Mr. Kokomo. Do you recognize what's been marked as 60 VV?
Yes, it's a video of his story in its entirety.
Okay, and is that the way you saw it on social media?
It was both a video that was submitted in discovery and a photo that was submitted. The relevant portion of that would have been relevant to our investigation was that you're posting a video the day after somebody's murdered in your presence.
We haven't even gotten there yet. Do you recognize
Yes,
that video? Okay. Your Honor, I would move to admit DS 60 into evidence.
Admit it?
Permission to publish.
You may.
Your Honor, may we approach before it's published?
Yes. we're gonna, given the time, and we need to sort out something anyway, we're gonna break with y'all for the day. And so we'll see y'all again tomorrow at we have a late start, 10:30 with y'all. Is that right? Whatever I told y'all before is what I mean. I can't remember what it was, but whatever I told you. Everybody just be here then. 10:30. Hang on, y'all. Let's see. Today it's 10 is what we have, what I have on my calendar. So 10. See y'all at 10. Good try though. All right, and y'all are gonna look this evening to see exactly what the outcome of was when we discussed this particular video before. And we're quickly getting to, I think, needing to do charge conference, and I appreciate y'all's work on this late last week and over the weekend. And I think that there's, you can go. We'll see you at 10 in the morning. Thank you. A lot of it there appears to be agreement on. I think the challenging part, if there is one, is going to be figuring out exactly what needs to be charged with regard to RICO. But I'm wondering, certainly in the morning before we have the jury, but maybe for a little while tonight, if we wanted to go ahead and start getting through some of that, maybe can y'all, unless there's any reason, I'd love to maybe take 45 minutes or so tonight and then get together in the morning and try to at least wrap up everything other than RICO. Does that sound reasonable?
Yes, Your Honor.
Okay. And then, obviously, I'll get a final determination after the state rests of whether the defense wants to present a case and whether the defendants want to testify and what have you. But at some point fairly soon, if there isn't going to be a defense case, we'll need to tackle the RICO. And I think that the state wanted to bring Mr. Floyd in for that part of the argument. So I don't know exactly what the timing is going to be, but give him a heads up that, you know, maybe as early as tomorrow afternoon.
He's aware, Your Honor. We
Okay.
told him that it'll probably be this week sometime.
Okay. All right. So y'all have got a draft that we've all been working in, the state, the defense, and the court, exchanging emails back and forth. Not emails, but exchanging the document back and forth with various edits to it for the offenses. So if we all want to pull that up. And I assume, just for record purposes, that each side has filed what they sent originally as their proposed.
I have not yet.
Okay, but you can.
Would you like us to? Is that?
If y'all want to. I mean, it seems like we're gonna reach agreement as to the final form of most of this anyway, but if, you know, I'll just say if anybody wants your original version in a potential record, just file it. Okay.
Thank you, Your Honor.
Okay, and so as y'all all know, what Ms. Percival did was just take the state's charges, the defense charges, and consolidate them all into one document. And that's the document we're all looking at now. And anything that the court has asked y'all to think about, I have indicated that in some way in this document. And then y'all took a look at it and you have let me know the things that everybody might agree to. So let's just run through it. I think most of it won't take very long. So the very first one, and I just moved 1.20.30 up to the front because it seems to make more sense there than later. But I had suggested that we use the word admitted instead of presented when it says it's your responsibility to determine the facts of the case from all of the evidence either presented or admitted. And the defense is fine with that, and the state has questions, is what y'all's note says. So what is your question about that particular change? Or I can just explain why I think admitted is a better idea than presented, and that is because all kinds of evidence gets presented but ultimately excluded. And obviously, they can't consider anything that's been excluded, whereas they can consider everything that got admitted.
And I think my question, Your Honor, was regarding testimony. We normally say admitted as to physical evidence, but if there's testimony, we normally don't say listen to the admitted testimony. And so I didn't know there would be some confusion that what was testified to is something different than the evidence that was admitted versus like versus pictures or physical.
Yeah, so there's down below, there's going to be an explanation of what evidence is, and it's going to say it's both exhibits and testimony. So evidence encompasses both of those things, and I hear your question, but I'm going to go with admitted for the reasons I already explained. And then the indictment, it sounds like the state agrees that we'll just read out the charges that each of the defendants that are still with us is charged with. Is that right?
Yes.
Okay. My question is kind of whether in reading the indictment, y'all want me to read every one of the 150 or 60 something overt acts, which I'm not particularly excited about considering they're going to have a paper copy of it out with them. Thoughts on that?
Your Honor, our preference and our argument is that for count one, just the charges be reread.
191 overt acts.
Yeah, I don't think we need to read the 190. I also don't think we need to read the preamble
I
to
don't
the
either.
191 over acts that the state wrote in the indictment. So I believe it would be, I mean, they've already heard Judge Glanville read it before in jury selection, and I think before we swore in the jury, and I think it would be prejudicial just to
Well,
continue.
I don't plan to do it because they're going to have it out with them anyway. They'll be instructed about how to consider them all. I don't need to read every one of the overt acts, so I don't plan to do that. Okay? All right. 1.1, I suspect that's 10.20. Everybody agrees that's fine. 1.2010. Everybody is fine with, and I had just added its pattern, except that I had just added basically like, you know, generally speaking, these charges are going to say a defendant, but obviously you have to make a determination separately as to each defendant, and everybody seems fine with that. All right, so down towards the bottom of that particular instruction, and I'm on what's currently page 4 now. The highlighted part, it says I had noted that this was not pattern, this particular language. And interestingly, it says acceptable to defense, but state has questions about the changes that I made. The state's the one that requested the original version of that. So I had stricken through after hearing and seeing the evidence and just changed that to after considering the evidence. I struck presented in this case because that's just surplusage. It's obviously the evidence in this case. And then I changed it is your duty to convict to you would be authorized to convict. What are the state's questions or concerns about those changes?
I would need to, look, I believe, when this was pulled, there was language that said it is your duty, and so I need to speak with, the state representative who drafted this.
I know it said it is your duty. I struck through that because it's not what we say as judges ever when we're telling, every time we're talking about you can acquit or you can convict, we never as judges say it's your duty to convict. We always say it's your duty to acquit, you'd be authorized to convict. So that will be the way I'm saying that. And then, so was that your only issue with that one?
Yes, Your Honor.
Okay. All right, y'all are fine with grave suspicion, y'all meaning both sides. Both sides are fine with the general charge on evidence. Y'all will put together what the stipulations are. And y'all need to do that fairly soon.
Yes, Your Honor.
And I think that all the stipulations have been stipulations of facts, not stipulations about testimony, documents, or exhibits, which is why I struck that last part, because I don't think it's applicable. If that changes once y'all look back, just let me know. Okay, moving down to 1.30.20. As y'all all know, there's a short version and a long version of the direct and circumstantial evidence explanations. And both parties had requested the long version, which is fine. The red additions, none of those are non-pattern. Those are all pattern language. They're just from the short version. So it's kind of intermixed in with the long version. But there's the one defendant, in considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. And the note was defendant subject to this non-pattern language and that it's unnecessary. State finds the language acceptable. That actually is pattern language. So, I mean, y'all can still object, but given that it's pattern and been pattern for years and years, I'm going to go ahead and give that. Y'all okay with that?
My objection is, and I understand what the court's saying, my objection is that the instruction as a whole is essentially saying there's no difference between direct and circumstantial where it comes down to it. And I didn't see the need, it seems, to put in considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions.
All right. So one thing I wanted to know is when I normally give this charge in other cases, I have said that language at the very beginning. So you'll see where there's that green paragraph right below the heading. Evidence may be either direct or circumstantial or both. If you would rather I say it there, I didn't know if there was an objection to where it was placed.
I don't have a preference where
Okay. All right. Is there an objection to the language about there being no legal difference, or are you okay with that part? In the weight you can give to either direct or circumstantial?
I'm trying to find that language. Oh, I see it now, I'm sorry.
Right now, I have it at the sort of towards the bottom, but I could also do the green paragraph instead.
I don't have any preference.
Problem with that? Okay. Okay. All right, so next was inferences from the evidence or lack thereof. This was requested. Okay, you're going to withdraw that one? All right. All right, credibility of witnesses, everybody's good with that. And while the intelligence possibility has been either inserted or reinserted into the pattern charge, I would be disinclined to give that unless the defense wants that.
Are you, Your Honor, are you telling us it's been reinserted into pattern, or are you at?
Well, I don't know if it ever got removed, but it is, I looked and it is still in the pattern.
I think it's disfavored.
It is definitely disfavored. So unless y'all want it, I would not want to give that
That's fine.
particular. Okay, so we will get rid of that particular quality, I guess, including that one. Okay. 13130, expert witnesses, seems fine with everybody.
Yes, Your Honor.
All right, on the 3140, state's going to make a list of prior convictions under 609 is what the note says. I mean, are y'all wanting me to read those? Because I wouldn't plan to read those.
I agree.
Okay, so y'all don't have to make a list of them unless you want to. So,
I'm sorry, we're talking about listing the individual convictions?
yeah, which they have now said they wouldn't want either, and I wouldn't do regardless. Okay, so do we have, we charge only the ones that apply. Do we have evidence offered to attack any witness's credibility with a character for untruthfulness shown by bad acts, as in specific instances of conduct?
I think, I don't know if it was introduced in that way. I can't remember if Your Honor was here. Mr. Copeland was on the stand, and there was discussion about an incident where he accused a jail worker of beating him and tasing him and macing him, I believe.
Okay.
And then he was charged with false report of a crime, and then it was dismissed by the state, how it all came out.
Yep, I was
And
here
so,
for that.
so I do believe that would fall under 24-608A.
Okay, so I think we would say, this may include evidence of character for untruthfulness shown by specific instances of conduct of the witness in question. Was it brought out on cross-examination? I would imagine, brought out, okay. So just not the shown by bad acts, just shown by specific instances of conduct. Okay. Do we have bias toward a party shown by specific instances of conduct? And that would be either for or against a party. If y'all both, want it, whether we have it or not, I can charge it, but.
I don't recall that, Max.
I wrestle with Mr. Copeland's testimony because there's a lot of things that came out regarding things that Mr. Copeland did that could show bias towards a party, bias in favor of the defendants. If that would include him shooting.
Can you speak into the mic, please? I mean, I can hear you, but it's a lot easier when you're speaking into the mic.
If that would include him shooting at the studio.
Or grab a remote movable mic. Okay, so you think, yes, there are some of those?
Yes, Your Honor.
Okay. Any objection by the defense to giving bias towards a party shown by specific instances of conduct of a witness that may relate to the witness's bias toward a party?
No, Your Honor.
Okay. And then obviously we have some criminal convictions. But we don't have, we have definitely felony. Do we have a crime of dishonesty or making a false statement for any of them?
I don't believe.
All right, y'all double check with me. We can just highlight that for now. And y'all double check. I don't think we do, but okay. And then, do we have character for untruthfulness shown by opinion or reputation? Other than Woody himself saying, I lie about everything. That's not an other witness, though. That's himself.
No, I don't think so.
Okay. And then we've covered the specific instances up above, right?
Yes.
All right. So we can get rid of that part. Okay. All right, next is 1.31.42, witness supported, the state requested this, defense objects. We've just determined that credibility has been attacked in some of those ways, so what part does the defense object to? Has there been evidence offered to support the credibility or believability of a witness whose credibility has been attacked?
I don't recall that evidence.
We don't have a specific, do we have specific instances of truthful conduct or lack of bias?
I don't recall that either.
Antonio Sledge is what.
Okay. So I guess, yeah, Antonio Sledge certainly would be included within the specific instances of conduct that may relate to his character for untruthfulness, I would think, if there was some evidence that he lied under oath. Right?
Well, that was, the way I looked at it, that was impeaching him about the statements at hand, not, the way I view this as like, you have a history of lying about prior things, not, we're calling you a liar today in court.
Okay, well, regardless, what is the defense objection to the 0.31.42?
Well, this is about, as I understand it, it's about rehabilitating someone whose credibility has been attacked. And I don't recall any positive character evidence of truthfulness provided by anyone, and I don't remember any testimony about the lack of, like, this is rehabilitation, and I don't recall any rehabilitation of any of these witnesses.
So has there been evidence of character for truthfulness? I don't think so. Or lack of bias?
Sorry, Your Honor. No, there has not been.
All right, so what I think I typically do is if those specifics don't apply, because the pattern says this would include and then gives the example of character for truthfulness or lack of bias, we can just give essentially the first sentence of that pattern without the example. So it would just say, in determining the credibility of any witness whose credibility has been attacked or challenged, and any testimony by him or her in court, you may consider, where applicable, evidence offered to support the credibility or believability of any such witness. Any objection to that?
No, Your Honor, none of them still.
Defense?
No, Your Honor.
Okay. And then 13145, y'all are fine with. 3147, y'all are fine with. 3180, everybody's fine with?
Yes.
Okay. 3190 and 92, y'all are fine with?
What about
Yeah.
90 max?
This is,
Well, sorry, I mean, it says state and defense agree no changes, which is why I said that.
That
If
wa-
I'm
that was on-
wrong, go ahead and
That was
let
on
me know.
92, Your Honor.
on 90, I objected, but if this is
Oh,
pattern,
I'm sorry, it doesn't have any indication that you objected.
I did, but maybe.
Okay, that's fine. I mean, yeah, if I skip something or if the notes are wrong that Mr. Weinstein did,
That would be my note-taking, Your Honor.
then, yeah, please let me know.
It-
Okay.
But and the reason I objected is I was under the impression that this was now disfavored. But if it's not disfavored now, then I was thinking about the Noggle case, and I think I was mixing up this versus the presumption of truthfulness.
You might be
instruction.
more up on it than me, so
Okay, let me-
if you
yeah.
want to take a look back at it, and if it's disfavored, then certainly we
Okay.
would think about, but.
I'm not saying it is, but I'll
okay.
look at it.
All right, so double check on that. All right, any preference on 9.2, whether I say testimony of an accomplice on its own or a testimony of accomplice by itself? Anybody care? Nobody cares? Okay. All right, I'll pick one. Okay, 9.3. Y'all agree? Oh, I'm sorry, 9.3A, y'all agree. 9.3B. Y'all are saying this might need to come in because of the statement by Stillwell when he was a victim. Is that right? Or that it was his Audi? That's fine. I wasn't thinking about anything like that, but that's fine. We can give that. And then assuming that neither defendant decides to testify, we'll give 3210. All right, 3216, it looks like everybody agrees we don't need that one. Or all the way, or 1718, 50,
And I will say, just for the record,
yeah.
that I am cognizant of the fact that Mr. Stillwell did give a statement. I think it was not ruled to be custodial by the prior judge. Arguably it is, I think, in the back of a car when he was the victim. That being said, I'm not going to be arguing at all that it's not voluntary or even go down that road about proof of voluntariness or conditions precedent. So I just want the record to reflect that I'm knowledgeable about that statement, but I don't believe that these apply, and I wouldn't be making any arguments
All
to
right,
this effect.
thank you.
Yeah, and I'm not objecting it to being removed because
All right.
Mr. Kendrick's statement did not come in.
Okay. Okay, and then 1.3400, everybody's fine with that as it reads right now. 1.3420, prior difficulties. I had asked, do we have this? And it says defense does not believe this needs to come in. State believes Copeland's prior statements might necessitate this instruction.
Yes, Your Honor, so in Mr. Copeland's statement to the police, specifically his June statement, he discusses that at the time when he does the statement around June of 2015, that he thought that Mr. Williams was trying to, even though Mr. Williams is not here anymore, but he did discuss that Mr. Williams, he thought was trying to kill him at the time, trying to harm him. And so we were thinking about that as far as prior difficulties. And that's what I was thinking of
Okay.
at the time.
All right, so this charge would talk about evidence of prior difficulties or lack thereof between a defendant and somebody else. And I mean, our only two defendants are Mr. Kendrick and Mr. Stillwell. So given that, what are your thoughts?
In that statement, there are portions where he talks about, where Mr. Copeland does discuss in that same statement his challenges with Mr. Stillwell at the time. And when I say at the time, I mean in 2015. It's not as profound as when he talks about Mr. Williams, Your Honor, but there is some evidence, at least through that statement, that at the time, back in 2015, specifically June of 2015, that his relationship with Mr. Stillwell was not the same as it had been previously.
All right, and if that were the case, then it would read evidence of prior difficulties between a defendant, I guess, and a witness have been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the witness. Whether this evidence illustrates such matters is solely a matter for you, the jury, to determine, but you're not to consider such evidence for any other purpose.
I still don't believe that we need that, Your Honor, especially because Mr. Kendrick is not involved in that alleged dispute.
I just think it makes it really confusing. Because we don't really have prior difficulties anyway. We have, at most, Mr. Copeland saying, you know, some version of, I'm worried Mr. Stillwell doesn't like me or has it out for me or whatever, right? We don't have actual, like, prior difficulties.
Correct, we don't have any, I think
Like, they didn't get in a fight or have a war over Instagram or anything like that.
No, we don't have
Okay,
that, Your Honor.
all right. I think it would be cleaner then to not include this. All right, 3430, everybody agrees with that as written, is that correct?
Yes, Your Honor.
All right. Identification, everybody agrees to 1.3510 and 11. As, yes, no?
Yeah, I'm sorry, yes. I was thinking whether we even had 13510, but I believe we did with some of the overt acts.
Well, we do for the, yeah, which is like the Ryan murder that he's been convicted of, and
There was an incident at a gas station on Jonesboro Road, I believe it was.
okay.
Or Lakewood, that also had identifications.
Okay, so on 1-1 though, we were talking about, normally that's talking about identifying a defendant as a perpetrator, which is not, we're talking about, do we have a defendant being identified as a perpetrator of any crimes either of them has been charged with, or are we just talking about overt acts?
I think we're just talking about overt acts.
I mean, there's no witness that identifies Mr. Kendrick as a perpetrator
To any of the crimes with
Correct.
which he's been
for
charged,
any of the
right?
counts, correct?
Okay. And I think the same for Mr. Stillwell?
I can't swear like if
I mean, it's,
in the interrogations of, or the interviews of Mr. Copeland or Mr. Zachary, I think they may have had like single photos and like said, do you know who this person is, that sort of thing, but I don't really take that as an identification.
Yeah. Right. What I'm trying to parse for myself is on 1-1, do we just say sufficiently identify the defendant beyond a reasonable doubt as the perpetrator of any of the crimes with which he is charged, which is like actually language that I added. Instead of, it normally reads beyond a reasonable doubt as the perpetrator. But if we're also need for them to consider, did some alleged co-conspirator commit some other overt act? And we do have eyewitness identification of potential co-conspirators committing overt acts, then
I think Rod needs to stay.
it's not really identifying the defendant then, it's
No, language.
identifying like any alleged co-conspirator?
The language would need to change in that case.
I could say sufficiently identify any conspirator? I don't even know. Y'all think about that with me. Because or we could say the defendant and then like also do another explanation for overt acts. Or not say anything at all. We need to come back to this one. Ms. Pershfield, just highlight that whole thing and maybe give us a note as to why we're coming back to it. All right, everybody agrees the fingerprint one is unnecessary. And on the DNA, we left that with, y'all's notes say that the state and the defense agree that this is probably unnecessary, but the state is double checking. What'd y'all come up with?
We had not had option to double check that.
Okay, well, double check, but I don't think there's any DNA evidence.
The only one I could think of was there was a 2013 alleged armed robbery where there was some blood in the car. But I don't know.
Did y'all have a DNA expert come say that blood belongs to anybody?
No.
Okay, well then we don't have DNA evidence. Although I'll leave it in until the state double checks. All right, 1.40.10, y'all are fine with it being said a crime occurs when the law is violated by a defendant's intentional action?
Yes.
Okay. Intent, everybody's fine with, no presumption, everybody's fine with. Presumptions and inferences, 1.41.12. Defense says it's inapplicable. It's not inapplicable. I mean, it's
Well-
always true.
It is always true. I don't think it's necessarily tailored to this case. I don't believe that that is going to be an issue at all about mental states, or there's going to be no mental defense.
Okay, I see what you mean by that. Thoughts on this? I mean, I typically give it, and typically mental health defenses aren't an issue, but state?
We don't think we need, however, we don't know what arguments may prevail if.
All right, I'll just leave it in. Okay. 1.42.10, parties to a crime, requested by the state and the defense. It says the defense does not object if this is tailored to the Donovan Thomas murder only. That would be interesting.
Yes, Your Honor. I don't believe that, obviously in some jury instructions, they apply to all acts. But sometimes they apply to certain acts and not others. Mr. Stillwell has been accused of being the shooter of Schmel drinks. There's been no testimony any other way other than him being the shooter, as being the principal, not as an accomplice, not as party to a crime. There's been no evidence that Mr. Stillwell is a party to a crime of the Schmel drinks case. So I would object, and I understand that the state wants it, especially with Mr. Kendrick. I'm not sure. It's unclear to me what role they think Mr. Kendrick played in the Donovan Thomas at this point, but I would assume that would be as a party to a crime. So I understand the state's request for that act. I don't think it applies to Schmel drinks.
So I think the state's evidence has Mr. Stillwell driving the Audi, and who's in the front seat with him?
D'Amico Garlington.
Okay. And then their theory is that the fatal shot came from the Audi from inside, that they didn't stick a gun out. I don't know if they've gotten to the nitty-gritty of it was Mr. Stillwell and not the passenger.
Well, they've thrown out hypotheticals of Mr. Stillwell opening the door, of Mr. Stillwell sticking his arm out the window. They also had Detective Hogan. I had him very clearly go through his warrant and his theory that Mr. Stillwell was the shooter, and we haven't heard any other evidence.
I mean, the detective's theory and what the state ultimately wants to present aren't, they're not bound to the detective's theory.
Absolutely, but now we're on the last witness,
Yeah.
and I still haven't heard anything contrary to the argument that Mr. Stillwell is the shooter from the passenger seats. I mean, from the driver's seat. So I just don't.
Well, let me
feel it's
pause and
appropriate.
ask the state if is y'all's theory 100% Mr. Stillwell was the shooter, or what's your take on this?
We can never be 100% because we were not in the car. However, Your Honor, we believe that Mr. Stillwell was the driver, but the jury can infer from the evidence that Mr. D'Amico Garlington leaned over and shot the weapon. We believe that Mr. Stillwell shot the weapon out of the driver's side vehicle, Your Honor, but with any of our pattern charges, nothing is tailored in an indictment to a specific charge. It's just read, and we argue based upon what the charges are. So we would ask that 1.42.1 to not be specified for any charge, but that it is a jury charge that is just read to the jury, not specified to a specific count in the indictment.
I mean, I've never given parties to a crime and said this only applies to, which doesn't mean it can't be given that way, but I've never even been presented with that argument. And frankly, well, okay, I mean, I hear and understand the objection, but I'm not gonna limit it.
And Your Honor, this is my fault. I just wasn't anticipating that we would be reviewing this today. If I can find some case law that.
Yeah, that's fine. And frankly, it's 5 till 6 and we haven't gotten through, and I know we don't want to be here until 7. So let's just pause right here for the evening, and let's, can everybody be back at 8:45 in the morning, and we can get through with, I think, this part of the charge conference?
Yes, Your Honor.
Okay, and I've been working on a RICO charge, but I'm still working on it. Does anybody have anything more to present than they've already presented on the RICO in terms of potential language? I know your argument, but.
Yeah, at this point, I don't have any additional language.
All right, well, I will share, so as the pattern jury instructions have been updated in plain language, and not all of them have yet, but like, for instance, murder has. And so now it reads, the state must prove 1, 2, 3, or whatever, and it's been done for a lot of those. There's been a move towards that. There is no pattern for RICO, but what I am trying to do is put the RICO charge in that same kind of format. The state must prove A, B, C, D, E, F elements. So if it's in enough of a form for me to share that, I can, through Ms. Percefield, share that with everybody to take a look at tonight. It is nascent still. It is not fully formed, but that way y'all can at least have some thoughts as to what I'm thinking would be a correct and also helpful charge for the jury. Okay.
Thank you.
All right, see y'all at 8:45.